Okay. All right, we will start in a minute. Please sign into the attendance. Okay, another 30 seconds, we'll get started. And please, as always, rename yourself last name, comma first. Thank you. All right, let's get started. I'd like to begin class by going over an issue that I think caused some confusion last class. Oh, by the way, tomorrow is Constitution Day, one of my favorite holidays. You may not know this, but under federal law, any school that accepts federal money must put on a Constitution Day event. I actually think this law is unconstitutional. You shouldn't be forcing people to speak about anything, but I voluntarily choose to. So tomorrow, Professor Kelso and I are doing a Constitution Day event at 3 o'clock, which you're welcome to attend. And if you're free, if not, don't worry about it. But we try to keep student life as normal as possible during this time. I just put for you the link to the Zoom tomorrow at 3. Here is the link to the class. Oops, I put in the wrong. Sorry, I put in the wrong box. I apologize. Zoom does a strange thing where it sends the messages to the waiting room, which makes very little sense as a default option. I don't know why. Okay, there's the link to the Zoom tomorrow at 3. And here is the link to today's class notes. All right, so let's start with question number 1. Okay, and actually it's 1A. Question 1 has 4 parts. So get your clickers ready. Now let's do question number 1 and then subpart 1A. So here's the question. You're in a notice jurisdiction, like Texas. O owns Blackacre. O sells Blackacre to A. A does not record. O offers to sell Blackacre to B for valuable consideration. Okay, now I get to question 1A. O tells B that he previously sold Blackacre to A, but A never entered. B purchased Blackacre. What kind of notice is there? A, actual notice. B, record notice. C, inquiry notice. Or D, B did not have any notice. Okay. Please go ahead and answer. Another 15 seconds. Okay. All right. Who is next on the list?
I am.
Okay. Thanks, Harrison. All right, Harrison. What is your answer here?
I put it's actual notice.
Okay. Why'd you put actual notice?
Well, O is. It doesn't look like he's acting in good faith. Actually, it looks like it's bad faith, and he's telling B, I sold this property to this person.
Mm-hmm.
I believe they own it, but you could probably get it because they're not there.
Yeah, but what's actual notice? I think you hinted at, but just tell us, what's actual notice?
I would say that it's...
And define it without saying actual or notice.
Okay. Making someone aware of the circumstances. Yeah.
Okay, but how do you make them aware? Just finish off the thought. There are different ways of making someone aware of circumstances.
by directly
Good.
informing them of the circumstances.
That's very good. Directly informing. I like that. Yeah, there are different ways you can say it. But the answer is A. And about 90% of you got that right. Very good. Actual notice is the easiest one. It's where the seller or someone else says, yeah, I sold this land to A couple years ago, but he never entered. No big deal. I'll sell it to you anyway. Right? And I think Harrison was right. This is basically an allegation of bad faith. Okay? All right. Let's do question now 1B. The facts are the same from 1, but we have a different setup. It says, during the closing period, a neighbor tells B that he vaguely remembers O already sold Blackacre, but the neighbor is not certain. B purchases Blackacre anyway. Okay, what kind of notice is here? A, actual, B, record, C, inquiry, or D, B does not have any notice. Okay, another 15 seconds. And Alexandria, you're on deck. Okay. All right, Alexandria, what did you put here?
Yes, I put that it was C, inquiry notice.
Okay, tell me why.
Since a neighbor told B that he vaguely remembers her already selling Blackacre, I thought that those were facts that were given to B that would reasonably lead him to further search or inquiry with another interest in the Blackacre.
Perfect. Okay, very good definition. Thank you, Alexandria. That's right. C is the answer here. I think 96% of you, I think almost all of you got that right. Very good. Inquiry notice is different than actual notice. With actual notice, you get evidence that someone else has an interest in Blackacre, like direct evidence. I think it's the word Harrison used. But inquiry notice is different. Inquiry notice is when you learn of certain facts that make you suspicious and make you want to do some more digging, your due diligence. You dig deeper. I think someone used that phrase last class, right? You want to dig deeper. And here you have a neighbor telling you, well, I think there's this transaction. I don't really remember the details, but I remember something's up. And if you are a reasonably prudent person and you hear this, you say, wow, that's not good. Maybe the neighbor's full of it. Maybe the neighbor has a grudge, or maybe the neighbor has a bad memory. But I should at least dig and try and figure out if there are any transactions that happened. You can always ask, say, hey, did you sell Blackacre to someone else? And if they lie, you get them for fraud. So there's actually a benefit to even asking that question. All right, so thank you for that, Alexandra. All right, let's go on to number 1C. Okay, try this question, please. B is performing his title search. As she is flipping through the indexes, she randomly comes across a deed in which A conveys Blackacre to C. B cannot figure out how Blackacre could have been conveyed from O to A. B ignores the issue and buys Blackacre anyway. Okay, what kind of notice do we have here? Actual notice, record notice, inquiry notice, or none of the above? He has no notice. All right. Nick, I'll call on you in about 10 seconds. All right, Nick. What is your answer here, sir?
I put B.
Okay, tell me why you put B.
So record notice applies whenever you have something on a properly recorded instrument that gives you any sort of reasonable doubt as to the title.
Good.
And the fact that, because she was flipping through indexes and she found it, we can assume that the deed was indexed. And so what the Lewis case tells us is that indexing is a requirement for
very good
a document properly recorded. So the record notice, I believe.
Very good. Excellent. And just, Nick, just let's clarify the point. What's the difference between inquiry notice and record notice? There's a subtle distinction between those two things. Between question 1B and 1C. What's the difference between record notice and inquiry notice?
Well, the main difference is just on the record notice, it has to be just an actual recorded instrument.
Very good. Okay.
That you see the information on.
Okay, perfect. Thank you. There are two kinds of constructive notice. Right, two types of constructive notice. First, we have inquiry notice, which was question 1B. And then we have record notice, which is question 1C. Okay? When you have constructive notice, there's something that puts you on edge, that something's not right. But to have record notice, you need something more. It has to be a properly recorded index. So in this question, I said that you're flipping through the indexes. We learned in the Lewis case that indexing is an important part of the recording process. You have to have it indexed. It's a funny thing when you're looking through books, you occasionally stumble across the wrong page, right? But if there's online, you just do a query, you're done with it. So there's actually some benefit to manually flipping through the books. You can maybe come across them by accident. Okay, so here the answer is B. I think 90% of you got this right. That's very good. Okay, I'm happy so far. Good job. All right, Grayson, go ahead.
If she had never randomly found that, would she have no notice?
Yeah. Exactly right. Yet, had she just not stumbled across that page, she would have no notice. Isn't that something, right? So she's actually being, well, I shouldn't say it that way, but the fact that she found it and didn't do anything about it suggests she's acting in bad faith, right? A reasonable person who finds that deed will say, whoa, what's going on here? Let me go investigate. Maybe I shouldn't buy Blackacre. She's being punished basically for her thorough research, but not taking steps to remedy it. Okay, that makes sense, Grayson? Okay, Blake, go ahead.
Sorry. I think Baron might have brought up this concept last week of if there's a gap earlier in the history of the deed, does that affect the notice? Because I thought this was a tricky question where they didn't have the notice because there was the gap, so it broke the chain.
Yeah, there was only notice because she found it by accident.
Okay, which is what Grayson did.
That was Grayson. Yeah, I think you guys are asking the same question, right? Had she not found this, then because of the gap, there would be no notice.
Okay.
So just completely, by chance, she found it and then she lost it. Yeah. All right, go ahead. Now, Diana, I think is next.
I was just wondering, I guess, because you said accident is why it's not an actual notice, because if she was doing her due diligence, looking at the record, would that have to be an actual notice, or does it have to come from the grantor?
Yeah, good question. Well, let's be careful. Which deed did she find, Diana, in this question?
A deed in which A conveys to O. I see. Okay.
No, say it out loud so everyone else sees it. I know you see it, but say it out loud.
Okay, it says she randomly comes across a deed in which A conveys Blackacre to C.
Okay.
And then just B cannot figure out how Blackacre would.
That's the key point.
From O to A.
Yeah, let me repeat that. There's no deed from O to A. Right? For all we know, A is a crook. And A just pretends to sell Blackacre without owning it. Right? It could be completely O could be completely honest here, right? But the fact that there's some deed from A to C for Blackacre suggests that maybe O isn't so honest. And that's what notice is. It means you have to dig deeper. You have to look into it further. And that's why you don't have actual notice that O is a crook. But you might have record notice that something's up. Make sense, Diana?
So, in the exam, can we have actual and record? If it would have shown that O...
if you have actual notice, I don't think record notice even matters at that point. Right? If you have actual notice, it doesn't even really matter. I guess you can have both. I mean, sure, but if you have actual, the analysis is over. Because you lose. You're not, right? You're not bona fide if you have actual notice, so you lose anyway. All right, Nancy, go ahead.
Thank you.
Aside from having like a third party conduct the title search and informing the potential buyer, hey, we found this possible gap.
Mhm.
How is record notice really going to come up? Because if
Rarely.
because you can't prove that I saw something.
Look, I came up with a crazy example I could think of that you randomly flipping through pages. I was like, how can I test this, right? But think of the case we had last week, the Harper case. There was a deed missing in a chest for 40 years, right? Record notice is going to be strange. It's going to be unusual. Because usually if you find evidence in the title search, you just won't buy Blackacre. You'll leave. You'll buy another property. So this only comes up either A, a person's acting in bad faith, right? Or B, there's some bizarre fluke that you come across it many years later. Make sense?
Sure.
No, not sure. But does it make sense?
No, it makes sense. It's hard to guess how this would come up in real life.
It's rare.
And be able to be proven. Yeah.
That's why the case in your book, the Georgia case, is so strange, where there's a deed that goes missing for 40 years, but there's another deed that referenced the missing deed. It's like, who the hell would even do that, right? The reason why your case has books, your book has cases, is they illustrate very strange principles of law in unusual circumstances. That's why you have them. I think of the haunted house case, right? Why on earth is that case in your book? Because it's the only case that has that principle. So that's why we have these sorts of cases. Okay. Make sense, Nancy? Good, thank you. All right, let's try the last one. I think this can maybe, we're almost done with this topic. Now this is 1D. B is performing a title search. She does not come across the deed from A to C. So I'm changing the facts. And then B goes ahead and purchases Blackacre from O. What kind of notice is there? Actual, record, inquiry. B does not have notice. Okay, and I'll be calling on Madison in about 5 seconds. Okay, Madison, what is your answer here? I can't hear you, I'm sorry. Maybe unplug your mic.
Can you hear me now?
Got it.
Okay. So I put that B does not have notice.
Okay, why?
Because that B performed a title search and didn't find anything, and then there was no other facts or circumstances that would have proved them to do any more due diligence.
Now this is basically the flip side of Nancy's question a minute ago. Why did B not find this deed in the index? The deed from A to C. Why would she not have found this deed doing a reasonable search?
It may not have been properly recorded.
It was recorded. It was. My question is, why would B, performing a reasonable search, not have found the deed from A to C?
Would it have been starting in the grantees index?
You're not thinking about this question the right way. When B is buying Blackacre from O, what name is she looking for?
Looking for O.
Okay, good.
So it wouldn't have been in the chain of title.
What wouldn't have been in the chain of title?
From A to C.
Why? Why would that not have been the chain of title?
Because B would have been looking from something to O.
Would B have been looking for A's name anywhere?
No.
Would B have been looking for C's name anywhere?
No.
Can B search for everything involving Blackacre? Is that a thing you can do?
You have to go off of the name you have.
That's it. And do they have A or C as a name?
No,
okay.
We didn't have that.
All right, very good. Thank you, Madison. So the trick here is that D is correct. D has no notice, but you have to know why. The reason why there's no notice is that B is not expected to know about A. B is not expected to search for C. The only name that B knows about is O. That's his grantor. And he would start in the grantee index looking back and back and back. This is what's called chain of title. I think Madison used that phrase. The chain of title refers to the documents that you're expected to search for, right? The names you're expected to look for, right? B is searching for O. That's his chain of title. B does not know about A or C. He has no reason to even suspect that. So there's no obligation to find those deeds. Okay. Everyone okay with that? Any questions? And that was 98%. That's as close as we're getting to 100% in this class. So that's very good. Only one person got it wrong. All right. Let's do question number 2. Okay. So this is kind of a preview. If you need to scroll up, you can. In which of the previous questions was B a subsequent bona fide purchase for value without notice? Question 1A, question 1B, question 1C, question 1D, or all of the above? I wish it was an F, none of the above, but that's not an option. I can't. I really wanted it, but the app wouldn't let me do it. I thought about it. Give them an option F, really screw with them. But all right. And I've noticed a lot of you are entering your answers before you even read the question, which is good, which means I think you're doing these in advance, which makes me happy. They're posted always the night before, so you should definitely take a look at them before you start class. Nancy, the link is immediately above your, it's in the chat, immediately above where you put your note in. Thanks, Chance. All right, who am I up to? I think Mackenzie here?
Yes.
All right, Mackenzie, what is your answer here?
I put D, 1D.
Okay, why is 1D, the facts 1D, he's a subsequent bona fide purchase for value without notice? It's a mouthful, but just in your notes for now, just write out subsequent bona fide purchase for value without notice. You can, on the exam, someone's great. Was it SBFP? VWN, my God, I hate these acronyms, but just what's the answer here, Mackenzie?
Well, I think it was 1D because to be a subsequent bona fide purchaser for value.
Yeah, good.
Be without notice, and 1D was the only one that we determined B did not have any type of.
Very good. Excellent. So, Mackenzie, just to wrap it up, if you have actual notice or constructive notice, are you a BFP?
No.
Good. Perfect. Okay. Thank you, Mackenzie. Right. So the reason why I put this question here, number 2, is to illustrate a point. If you have any kind of notice at all, you are not going to be a BFP. Right? You're not a BFP. Why does this matter? You want to be bona fide because you can rely on the protection of various recording statutes. Say, well, I didn't know. I was a good faith buyer. But if you don't have BFP status, guess what? The first in time wins, right? The first purchaser, the first buyer wins. The only way the subsequent buyer can prevail is if they're a BFP. If the subsequent buyer is not a BFP, the first in time wins. So go back to our question at the very beginning. O sold Blackacre to A, right? O sold Blackacre to A. O came first to A. A will win unless B is BFP. If B is a BFP, then B might win, right? Because A didn't record, so A can't rely on the recording statute. So you need to know who's a BFP to see who wins between A and B. Nancy, go ahead.
What about with inquiry notice? If you do a title search and nothing comes up, it hasn't been recorded, can you be?
Well, let's say there's inquiry notice where the neighbor says, I think something happened, right? And you investigate and you can't find anything. At that point, you've done your due diligence. You're fine. right? You're not expected to be Sherlock Holmes where you find like a missing hair and you figure out whose hair that is and you track down the DNA. You know, I'm thinking of an insane example, right? It's like you find a footprint on Blackacres. Aha, that's A's footprint, right? Reasonableness, right? There's a reasonableness standard that you're expected to follow. Okay, that makes sense? Okay, thank you. I like that little privacy divider you put on the desk behind you. It's actually really smart. I like that.
The kids' privacy board?
Yeah, I like that. Yeah, it's actually a really good idea.
Yeah, one of mine found a sticker that he decorated with a curse word. So there was quite a disruption in our home.
He's staring at you right now.
He heard me.
Bye. Okay. This is one of the enjoyable aspects of Zoom. You get to see, how people live. Whatever. Okay. That's actually really, those screens are actually a very good idea. I actually kind of like that. All right. So we have question 2. All right. Any questions on those? I think at this point you should all understand the differences between inquiry, record, and actual notice. A couple of you asked that in the minute poll. By the way, if like 3 people asked me the same question in the minute poll, then I know I have to do it because it didn't make sense. Like that's just the law of numbers. If there's 3 people, it's like, okay, I got to redo it. Yeah, Allison, go ahead.
Okay, this is probably obvious, but if you have a deed that references it, but you didn't come across the wording of it, like you didn't like see that it referenced a different deed, is that still record notice?
You mean you didn't read the document? Is that what you're saying?
Yeah, or you didn't understand the document. I mean,
well, those are different things. So if something's written there, you just sort of skimmed it, then I think you're in trouble. But let's say that the language was very, unclear, then it might not be enough to put you on inquiry notice. The fact is, in the Harper case, had they omitted that language about the lost deed, it would have come out the other way. So I guess there's an incentive to say as little as possible in deeds, I suppose. But, you don't know at the time how people are going to read it many years later.
Okay, thank you.
All right. One other point from last class I didn't have time to work on is title insurance. Title insurance is a way to protect yourself. If I am buying Blackacre, I'm going to hire a company and say, look, you do the search. You tell me for sure, company, are there any other interests? And the companies are happy to do this because they make money. I just did the math. I think for a $100,000 house, a policy is about $800. It's not terribly expensive, but it's a cost. But the benefit is not that they give you the certification that there's no other interest. It's if they make a mistake, it's an insurance policy. They can actually pay to fix it. Right? So let's say there happens to be a mortgage on the property that they don't disclose. The title company would pay off the mortgage. Or let's say, worst case scenario, O sells you Blackacre, but O doesn't actually own Blackacre. You might get the purchase price back from the insurance company. So it's a very useful and necessary thing which everyone should use. You don't have to. There's no requirement to. Although I can't imagine why someone wouldn't want it. These companies are very good at what they do. They do very accurate, thorough searches, and they know they don't make mistakes, right? They wouldn't write you a policy if they were unsure. If there's some property where it's really sketchy, the history doesn't line up, they just won't write you a policy, right? They just want to insure it. So they're only writing policies for things they're sure about. Okay. That's all you need to know about title insurance. Don't worry too much about it. If you ever buy a house, you'll know about it, and then the company will do it. You don't have to think about it. Don't do it yourself. It's too risky. Not worth it. I know you're all smart property students. Don't do it yourself. Pay someone. I would never do it myself, not even for a minute. Okay. Let's do some other poll questions to get ourselves thinking about nuisance. Now, I know you all took torts already, so you already studied nuisance. So I want to hit it from a slightly different angle. I know you did Del Webb and a few other cases, but a little bit different angle. Okay, here's question number 3 for you all. Damages can fully compensate a plaintiff for a nuisance. True or false? All right. And Samantha, I'll call you about 10 seconds. All right, Samantha, what's your answer here?
I put false.
Okay, tell me why.
Because damages does compensate a plaintiff to a certain part, but also injunctions are needed to further compensate the plaintiff.
Okay, Mackenzie. I'm sorry. Samantha. Sorry, I still looked at the last name of the list. Samantha. I'm sorry. Mackenzie. I apologize. I actually know who you are. It's last year I had this little 10 cards. Zoom's even better. A little name right in front of your face, so it's actually easy to learn it. Samantha, what is an injunction?
An injunction is the court telling the company or whoever is causing this nuisance that either they temporarily have to stop or they permanently have to stop or some other decision.
Okay. Okay. All right. Very, very good. Thank you so much, Samantha. Okay. In nuisance law, there are two primary types of remedies to think about. Damages, number one, and injunctions, number two. Damages and injunctions. In this topic for today, I am not really concerned about whether or not there's a nuisance. That's your tort study, right? If you notice, the opinions actually have very little discussing why something's a nuisance. Like, yep, it's unreasonable, it's improper. Confession, I don't like torts. I just don't like it. I think a discussion of reasonableness is garbage, right? Just whatever. There's no law there. It's just whatever. So I don't like those standards. I am much more concerned with remedies and how to alleviate. That's not garbage, is it? But just it's too much fluff for me. It never sat well with me, even in law school. I like rules, not standards. But what I want you to learn from this topic is not so much whether there's a nuisance, whether it's public or private or any of this stuff, but rather what is the correct remedy to compensate a person for the nuisance. All right, so you can have damages or you can have an injunction. Okay? Alexa, you here?
Yes.
Okay, thanks, Alexa. See, I'm not saying Joan. Looking at the chart, know your name. Okay. All right, Alexa, so let me ask this question, please. What is the purpose of damages? And I'm sure you've said this in like 3 classes already, but why? What are the purposes of damages?
To compensate for an injury.
What kind of injury?
I mean, it could be like someone broke your leg.
No. I'm sorry. You're right. You're giving an example of types of injury. I'm saying, when did this injury occur?
If we're talking about nuisance, whenever they started making the loud noises or started creating the environment.
So you're talking about present injuries, past injuries, future injuries? What are we talking about?
For all of them.
Oh, tell me. How can damages compensate for, the past, present, and future? How does that work?
So with past injuries, you're going to want to compensate for any value in the property that might have decreased because of this new company. Future injury really is more injunction though, not compensation.
Okay. Let me ask you another one, Alexa. Can damages be used to compensate a person for future injuries?
I mean, it can, but they're usually when someone is suing for nuisance, they really want the activity to stop. So,
I know that's what they want, but my question is a little bit different. Can you use damages to compensate someone for future injuries? Is that even possible?
I mean, I'm sure you could. Anything's possible.
Yeah.
I'm sure for the right price, you can get someone to stop complaining about a nuisance.
Oh, that's such a good answer. What do you mean for the right price to get someone to stop complaining? It's actually very good how you framed that.
I mean, if you give them enough money, they'll stop complaining, is what I would say.
So
if I compensate for whatever your decrease in value is going to be, if you ever sell the property, then maybe they would stop complaining about it.
Nailed it. Perfect. Yep, you're on this. It's very good. Okay. There are 2 things here that you said are very important, right? Damages are traditionally for past losses. So think of your classic tort case, right? Someone runs you over and you have $100,000 medical bill, right? in that case, the damages could compensate for your $100,000 medical bill. But damages can also be future in nature. Lost earnings, right? Ongoing pain and suffering, if that rings a bell. My favorite, loss of consortium. If you don't know what that is, Google it. Nancy, don't tell your son about that one. Right? These are things that you can calculate that happen in the future, right? Damages can be calculated based on what happened in the past and what you anticipate might happen in the future. Now, in torts, future damages, are kind of obvious, right? Here's your education. Here's what your income level was. You're expected to live to 75. You can calculate with some degree of certainty how much you make over a lifetime. Right? I've always found this perverse in torts. It's sometimes better to kill the person to leave them alive but injured because it's cheaper, right? It's a bizarre aspect of damages, right? There's no lost wages if the person. Anyway, put that aside. Sometimes it's more expensive. They're on life support their entire life. But you can compensate for future damages. But in property, it's a little bit different, right? Because a house doesn't generate, a salary. A house doesn't have pain and suffering. A house doesn't have, consortium, whatever that would even be. I don't even know what that would be, right? So when you calculate future damages in property, it's based on how will the property value be diminished if this nuisance continues. So I think Alexa framed it in a very funny fashion. For some price, everyone has a price, right? For some price, you'll live with the nuisance, right? You have a cement factory next door. You have an oil refinery next door, right? You have a loud air conditioner next door. You have a feed lot next door. At some point, you say, well, that's a lot of money. I can get some earplugs, right? Or I can just move. But here's the key point. When you're calculating future damages, those are only for the benefit of the current owner of Blackacre, right? Because your current owner moved there and everything was nice and quiet. And then along came a nuisance and made things noisy and loud. What happens if I want to buy Blackacre? And I see, well, Blackacre is located next to a garbage dump, or Blackacre is located next to an oil refinery. There's no surprise there, right? There's not a surprise. You know what you're getting yourself into, right? You can't move on to Blackacre and then sue the oil refinery saying, oh my God, there's a nuisance. No. You was there. You knew it, right? It wasn't a surprise. So the idea of damages is it's like a one-time payoff for the current occupant to compensate him for the reduced value of his property. Let's say that again. The concept of what are called permanent damages, right? Not temporary damages, permanent damages. With permanent damages, there's like a one-time payoff to compensate the present owner for the diminution of value of his property, the loss of value, right? Everyone has a price. I think Alexa said that very well. I don't need to say this in a mean way. Everyone has a price, right? For some dollar amount, you will leave your house. For some dollar amount, you'll say, you know what, screw this, I'll move to, a nicer house. I'll just take the money, right? Everyone has principles, but there's always a dollar amount. It's just human nature. So we have two kinds of real damages. We have the temporary damages, which are usually designed to compensate for past losses, right? Loss of enjoyment, you couldn't entertain company, there was, maybe you became ill because of gases being emitted. But those are temporary damages that cover past losses. The more important one is permanent damages, right? Permanent damages cover the future diminution of value of your property. And it's a one-time payoff, right? You don't get to come back and ask the oil company for an annual, payment. It's whatever that amount is, you calculate it now, and that's what you pay. Okay? So does everyone see that you can actually use future damages as a way to address nuisances. This was the Boomer case by I won't say it. This was the Boomer case, by the way, where the court basically said we don't really need an injunction if permanent damages are paid. And I think the Boomer approach, if you want to say majority, minority, this is probably the more common approach now. Injunctions are disfavored. And in many cases, damages may be a better remedy. Okay? Who's next? Alexa. Ashley here?
I'm here.
Okay, Ashley. Let me ask you a question, please. Why do you think in modern courts and modern trends, injunctions are disfavored, but permanent damages are more preferred? Why do you think that's the case?
Probably because balancing interests or equities, and if you have to look at if they're going to shut down maybe something that's a nuisance. And people, you would look at if people are losing their jobs.
Good.
And so that versus you could just award damages. And so I think it's a balancing and what's going to benefit the public. And
I think, Ashley, so let me ask this question if I can, Ashley. When a court is issuing an injunction, does it only consider the harm to, for example, the factory? Is that the only harm it's considering?
No.
What else is in any injunction, the court considers not only the factory or the cement plant, what else is the court going to consider? What's that phrase? It's an important element of an injunction analysis.
I'm thinking of whether it's going to benefit the public.
That's it. That's it. Doesn't look at the public. Yeah, you got it. Say it again.
Would benefit the public.
There you go. Good, very good. Thank you. Public interest, right? Whenever you are practicing as an attorney, which God willing you all will in a few years, you will seek an injunction at some point, right? Sometimes you'll say to your client, damage is not going to cut it, we need an injunction. And there are different factors to get an injunction. They vary from state to state and jurisdiction to jurisdiction, but in every jurisdiction, one of the essential elements is this injunction in the public interest? Right? Is this injunction in the public interest? Why is that an essential question? Because an injunction isn't limited to one party, right? With damages, there's one party paying it, and that's it, right? The company either pays it or doesn't. But an injunction affects the public at large. Think about it. If you have a cement factory that employs 300 people in upstate New York, and you issue an injunction, guess what? Those people are out of a job. If you have an apartment building in Houston that has, 500 people living there, and you issue an injunction shutting down the air conditioner, guess what? Those people are out of a home. It's not always so easy to buy an apartment, is it? Maybe you live there your entire life. You don't really have anywhere else to go. Living with family, who knows? When you issue an injunction, the public is affected. So the courts have to say not only is an injunction needed to address the nuisance, but also is this in the public interest? If the plaintiffs are suffering, a fairly trivial bother, it's a little loud, noisy, but 300 people will lose their jobs, how do you balance those equities? Right? How do you balance those equities? So the cases we have today represent kind of like a spectrum. Chance, I'll get to you in a second. The cases represent a bit of a spectrum. In the first case, was it the Penn oil case, right? Morgan versus Morgan versus High Penn Oil. The court issues the injunction because that was the older way of doing it. That if there's a nuisance, you issue an injunction. That shut down an oil facility. In the second case, the case from Texas, Estancias, this is with a loud air conditioner. Again, the court issues the injunction. What happens to all the people who live in that building who maybe have to move? But in the third case, Boomer, the court, they kind of issue an injunction, but not really. Their preferred remedy is damages. We'll get there a little bit later in class. And they basically say, we don't want to shut down this factory. This is too big of a deal, right? That the injury that the plaintiffs are suffering is pretty slight compared to what this would do to the community. So what you're seeing is a moving away from the injunction and moving towards permanent damages as the remedy. Okay, Chance, go ahead.
You do a preempt when you're trying to get an injunction of like preempting something. So say you have your air conditioning. Obviously, like I think Estancias, Dallas, Corp v. Schultz. If you did that nowadays, they would probably say, "Look, everybody's already in the apartments. We're not granting an injunction saying they can't have AC." But that time they did an injunction.
Right.
Well, if you were a homeowner prior to, would you still file an injunction saying, "Look, it has not affected us yet, but it will in the future. We don't want to let them build this"?
Yeah, right. So that's actually a good question. Thanks, Chance. So very often an injunction means stop doing something. Right? Stop doing what you're doing. But there are also injunctions to not do something. In other words, to maintain the status quo. Those sorts of injunctions are much more effective because no one's relying on it yet. If you see that your neighbor is building a jet engine air conditioning unit 5 feet from your house, right? You can go to court to get an injunction to stop it. At that point, there's no reliance interest, right? People aren't yet living there. People aren't using the AC. So it's a lot easier to get an injunction before the thing happens. Courts like to maintain the status quo. They like to keep things as they are. They're much less willing to disturb the status quo. Okay? We're with me so far. Now, one other thing to think about, after a court issues an injunction, right? Who's next? Monique, you here? Monique, you here? Adam?
Hey, how are you doing?
Okay, Adam. Thank you for asking. So, Adam, let me ask you a question, right? Let's just take Morgan versus Penn Oil as an example. The court issues an injunction. Do you think the company immediately shuts down their entire facility, fires everyone that minute, says, "Okay, everyone, you're laid off, go home"?
No, I don't.
What do you think happens after the court gives that injunction?
Well, I think in that case, the plaintiffs definitely have the upper hand.
Oh, upper hand in what?
In the fact that now there's a court order as the injunction stating that, that this refinery would have to shut down and the cost of shutting that refinery down. I mean, in this case, to delve a little bit in, they're all mobile homes, if I'm not mistaken. So the refinery, depending on, it seemed like it was pretty big, producing 60 million gallons. You'd probably have a cheaper time trying to just pay them off and
pay them off. What do you call that in legal speak? Pay off is such a dirty word. What do lawyers call it when they pay someone off? What's that called? Not a bribe, Chance. Go away. Stop.
Yeah, not a bribe.
It's not a bribe.
It's a settlement.
That's where I'm looking for. Thank you. Not a bribe. Go away. You're too much. Yeah. Thank you, Adam. Settlement, right? You will all be lawyers, God willing, soon, right? Settlement's good, right? Litigation's bad, right? Litigation's expensive. It's risky. It takes forever. And you don't know what's going to happen. You might get a rogue jury. You might get a crazy judge. There's so many variables, curveballs that can be thrown at you. But a settlement you can control, right? Now, there are two ways you can settle. Settle before the court rules or after the court rules. Before the court rules, maybe you roll the dice. You say, you know what? I think the court's going to rule in favor of the oil refinery. Right? So you don't settle. Okay. But if you lose, then Morgan has the upper hand. That's what Adam said, right? The upper hand. Because there's an injunction in place. If you make a settlement offer and Morgan says no, then you wave around that injunction, say, okay, I don't like this. Say bye-bye to your oil plant, right? Having the injunction in hand alters the negotiation process because there's no fallback. Basically, at that point, Morgan can hold out for whatever offer he wants. Whatever he thinks is the best offer, that's what he's going to take. Because at any point, he could say no, and then you're defaulting to the injunction. So the injunction is basically a post-settlement incentive, right? You get a much better settlement with an injunction in hand. Now, if the court had denied the injunction, then there's not much of an incentive to settle, right? Then, okay, you're not going to settle it. Maybe pay some damages and make them go away. So you see there's this relationship between damages, an injunction, and the settlement that comes afterwards. Generally, the plaintiffs prefer an injunction, and the party causing the nuisance, the factory or the refinery, prefers damages because they can keep their operations running. Yes, Gracie, go ahead.
I was just wondering if the court orders an injunction and then the refinery settles after the injunction's ordered, how do they get rid of the court order?
Okay, so it's a very good question. Generally, when a court decides a case, it doesn't go into effect immediately, right? It can, but generally there's some period of time after the court rules and before the order goes into effect. And that's often the period of time in which you have to reach a settlement. So maybe the court says, I will make my ruling in effect in 30 days, whatever the number is. That means you have a month to work it out. Right? You have a month to work out whatever details you want to work out. So as a result, you have an opportunity to settle and negotiate. Does that answer your question, Grayson? Okay, thanks. All right, everyone with me? All right, so just let me try to summarize and just sort of bring together these themes. Once you have a nuisance declared, courts can award damages and or an injunction. You don't have to pick. The Texas case that you have to pick, that's probably not correct, but that's how that case worked out. But you can sometimes get damages and or injunctions. Temporary damages are designed to remedy past losses. Permanent damages are designed to remedy future diminution in value. An injunction is always an option, although courts don't prefer them today. The White Oak Music Hall, Nancy. I don't know that case. Is that something in Houston?
Yeah, it's right on the outskirts of town. One of the firms I worked at handled it. It was a class action suit for the neighborhood.
So there was a music hall making lots of noise. I don't know the case.
Mm-hmm. Yeah, they built it in kind of right on the outskirts of this neighborhood, right next to the Heights, and it was causing everything from the vibration was causing things to loosen in their homes.
Yeah, the screws. Yeah.
Yeah, traffic, that people were parking in neighborhood streets, and then people couldn't get to their homes, and then our key plaintiff was a child with a sensory disorder, and
did you
disrupting him.
Did you get the settlement before or after the injunction?
After.
Do you know, Nancy? Yeah, go ahead. I'm sorry, I didn't interrupt you.
We had some temporary injunctions, and then finally, I think it kind of just wormed down.
Well, while I have you on that, let me talk about another case from Houston. Thank you, Nancy. Do you know all about the Ashby high rise? Is something you're familiar with? I've been talking about this case for the last 8 years in South Texas. This case never goes away. So in Rice Village, there's an intersection, Bissonnet and Ashby. And in like 2010, I'm talking like a decade ago, there was a plan to build a high-rise mixed-use development. And if you click on the class notes, scroll to the last page, I have some pictures. And they wanted to build in this, pretty well-to-do, affluent, wealthy area, this massive high-rise. Now, Houston has no zoning code. We'll talk about that later this semester. So the neighbors threw everything at the book at them to try and stop it, and nothing worked. Eventually, they argued that this building was a nuisance. It was a nuisance. How is it a nuisance? This was your theory of nuisance. Oh, Cassie says 2007. Thank you. It was even earlier than I thought. How is this building a nuisance? Well, follow me here. They said it was out of place. That this was a residential community and it didn't match the surrounding neighborhood. Now, that's not a nuisance in any sort of definition I've ever seen. Professor Festa, who teaches here, has been the national expert on this case. So if you ever want to talk about it, go ask Professor Festa. Okay, but I'm not concerned about whether it was a nuisance or not. The trial court actually awarded permanent damages. They said, well, the existence of this building will diminish values of neighbors nearby. I will not issue an injunction. Instead, I'll just issue permanent damages to compensate for their loss, which was probably the correct remedy, precisely because you don't need an injunction to stop it. You just compensate them for their loss. So the trial court basically followed the Boomer approach of doing permanent damages. That was reversed on appeal, and this case is just in this bizarre purgatory where it never ends. But the important point is the trial court actually followed the Boomer model and awarded permanent damages rather than an injunction. So in theory, construction could be in here, but it hasn't. It's still an empty lot. If you ever drive by the Museum of Fine Arts in that area, just drive a few blocks down Bissonnet, you'll see there's just this empty lot, just grass. There's nothing there. Okay. Questions on that one? All right. I think I've discussed the first three cases, the Morgan versus Penn, Estancias, and Boomer, and I can just summarize them briefly. In Morgan, you had the oil refinery causing the nuisance, and the court found it appropriate to grant the injunction to stop it. Now, I'm guessing after that injunction, the oil company settled quickly. These were mobile homes, I think Adam said, right? They can move, right? They can live somewhere else. Whatever it costs to buy them, everyone has a price. I'm sure Morgan held out for some high sum, but I'm sure they did not shut down the factory, the oil refinery. The second case, Estancias, is from our backyard. It's from Houston. It's difficult. I shouldn't say this. One year I said, who could live in Houston without air conditioner? And then some students said, I didn't have air conditioner growing up. I'm like, I'm sorry. I feel like a jerk. Right, but in Houston, it's difficult to live without AC. I think we all agree to that. It's a very hot place to live. And in fact, I don't think the housing codes allow you to have a building without air conditioner. So you have this AC unit that sounds like a jet engine. This is the case that I think is probably wrong. And if you read the notes after the case, it sort of hints at that also. The cost to repair the air conditioning unit is significant, right? It's several $100,000. Also, while the building is being repaired, people would have to move out, right? You have to have the HVAC ripped out, the ceilings ripped out, the walls ripped out. This is not like, putting a box unit in a window. You have to rip up the entire building. So you have to empty the building out and pay this massive cost to install it. Meanwhile, the Schultzes, the family next door, incurred maybe $10,000, $20,000 in damages. This would seem to be a case where an award of permanent damages may make more sense. You basically pay them for their loss and give them enough to make it whole, that they can move somewhere else and they're compensated for the diminution in value. Would anyone buy the house next to the jet engine? Probably not. Probably not. But the court here finds the injunction is appropriate. And in this case, he only got one. They only got the injunction. They got no damages. What happened afterwards, it's not entirely clear. I'm guessing they settled, right? Or they moved the air conditioner in some, they found a way to move it more cheaply. By the way, when a company causing a nuisance says it's going to be really expensive to fix this, they're probably lying because they have an incentive to exaggerate, right? They say, oh my God, this will be $1 million to fix, right? Not exactly. Let me give you an example from Dallas. If you go to the bottom of the, or actually on page 4 of the lecture notes, I have pictures of a building in Dallas. It's this huge, beautiful glass structure, and it's by the museum district in Dallas. Now, if you look at this photo carefully, you'll see that the sun is shining off the building, like my light ring shines on my glasses. That's the world we live in, right? At certain times of day, when the sun would hit this building, it would focus basically a death ray, right? This beam of light across the street at the museum. And at the museum, there was a rooftop garden, and the death ray would basically fry the grass on this rooftop garden. This was not something they anticipated when they built it. They didn't think about reflections, but it's a nuisance, right? It's a light nuisance in every regard. So there was a long debate, how could you fix this? There were some proposals to actually build these basic umbrellas that would open up at different times of the day to block the sun rays, these insane solutions. But the owner of the building said basically there was no way to fix it, right? You have to rip out every window in the building, which wasn't actually true. There were actually ways to put coating on the glass to soften the blow. But the reason why I mention this is that the owner of the building was actually posting on anonymous blogs saying that's impossible to fix, even though he was the one who said he knew how to fix it, right? So the businesses often lie about how expensive it is to remedy the injury. They're often exaggerating. But if this case were to actually go to a jury, I suspect they would get a settlement pretty quickly because they can't, demolish a building. It's just not possible. An injunction here wouldn't work. So either you get permanent damages or you settle the case. All right. The third case in the trilogy is the modern approach, which is Boomer. The Boomer court is kind of uncertain. They're like, we don't think courts should be resolving environmental disputes through nuisance cases, right? This is something that the states and the federal government should resolve through regulatory means. Why? Because an injunction only benefits the parties who sue, basically Boomer and his neighbors. What about all the other people in the neighborhood who didn't sue? They get nothing. They get not even a penny, right? One of the features of modern environmental law is that it doesn't require litigation from private parties, right? If your neighbor's polluting, you don't have to go to court. Instead, the government takes action on behalf of the public, right? That's how these environmental laws operate. It's for the public benefit. The government gets injunctions. The government gets fines. They can do either one. But it's not up to the private citizen to sue. But the Boomer court recognizes that there's precedent. And the precedent says that the preferred remedy is an injunction. So the court does something a little bit funny. They're very crafty at how they do this. It's very strange. The court says, well, we're going to issue an injunction, but not a permanent injunction. That injunction will dissolve as soon as permanent damages are paid. What? They issue a temporary injunction that will remain in place only so long as the damages are paid. Let me ask you, how quickly do you think those damages will be paid? Right away. As soon as the court issues that ruling, there's probably a check in the mail, right? Because they don't want this factory to shut down for a minute. People don't like the Boomer rule. I think the dissent states the point very well, that this is basically giving the court This is basically giving the cement company a license to pollute, right? They're licensing a continuing wrong. That's how the dissent phrases it. Or Alexa said, everyone has a price, right? You can continue to harm the neighbors so long as they pay a fee. And this does not sit well with people. It's a very uncomfortable ruling. They're basically paying to pollute. But the court says it's in the public interest. There are 300 people working at this factory. Millions of dollars were invested in this factory. It would not be in the public interest to shut down this factory. So they simply say, we'll give permanent damages to compensate the diminution of Boomer's property. This is a one-time payment. If Boomer sells his property, the new person moving in will know there's a cement factory there, and they can't complain. All right, so Boomer, I think, is the modern trend, if you want to discuss it that way. I don't know if it's majority rule, but it's the modern trend at least. And it reflects how I think the Ashby high-rise case, the trial court ruled. All right, questions on that trilogy, and I have the case summaries up. You can see the details later, but on those three cases, the Penn Oil, Estancias, and Boomer. Any questions? Yeah, go ahead.
I'm just curious, I feel like the Boomer ruling, that's a slippery slope. In the sense that, I'm from Pennsylvania, and fracking is a big thing, and it produces.
Oh, where in Pennsylvania you're from?
Right outside of Pittsburgh.
I knew that. You told me that last year. That's right.
Yeah.
I clerked in Western Pennsylvania. I know the area very well.
And you went to Penn State.
That's right.
Yeah.
Good.
But I guess my question is that at what point do we say, let's just reward damages and let's not do injunctions? For instance, like I said, PA fracking, people are getting poisoned by their own water, there's cancer-causing agents, and at what point will courts be like, okay, maybe it's time to not just look solely at economic value, but human livelihood?
Yeah, it's a good question, Adam. Today, in the year 2020, Boomer does not have much relevance for environmental cases. I think every state in the union has enacted environmental laws. That if someone's polluting or someone's emitting stuff into the water or into the air, they don't have to worry about a nuisance suit. They have to worry about the government coming after them. And the government can get injunctions, right? Because then it's in the public interest. It's not just, right? It's not just who is suing, right? It's not just Boomer suing. It's the state comes in and seeks an injunction for everyone's benefit. So Boomer was decided at a point in time where environmental laws were just getting started. I don't think the federal EPA, it was founded by Nixon, might have been in 70 or 71. The Environmental Protection Agency it was close, yeah. The Federal Environmental Protection Agency was founded in 1970, right? So when Boomer was decided, the EPA didn't even exist yet. So this was at a very specific point in time. Boomer doesn't have much relevance in environmental cases anymore. There are these complicated regimes. And let me answer questions from Adam a different way. Today, you don't just build a cement factory and hope it doesn't make noise, right? To build a factory, you need to have permits in advance. You need to conduct what's called an environmental impact statement. How will this affect the environment? So before you build it, you have to tell the government, look, we're not going to make any nuisances. We're not going to bother people. So you wouldn't get to the point where you randomly start polluting. Everything's in advance. That's why it's impossible to build anything, because you have all these hoops you have to jump through. But it shifts the review process from after the nuisance to before the nuisance. Right now, everything's done in advance. Make sense, Adam? All right. The last case is one which I think you all say in torch. Is that right? Yeah. Which I'll spend a little bit less time on it. Is Spur Industries versus Del Webb. I always say Spur Webb, like Spud Webb. Spur Industries versus Del Webb. Spud Webb was a basketball player in the 80s. And this involves a feedlot. Now, I didn't know what a feedlot is before I taught this case. Now I know. It's where cows feed, as the name suggests. And cows create a lot of manure. Manure smells bad. It creates flies. It creates risk of disease, right? It's not something that's good to have. And, we're talking about tons and tons and tons of manure being generated over the years. Just a lot of waste. The feedlot had been in this area in outside of Phoenix for some time. But this area became more popular. And developers started to move closer and closer and closer. Again, the feedlot didn't come to them. The developers came to the feedlot. This case introduced a doctrine that's known as coming to the nuisance. Right? Coming to the nuisance doctrine, where it's really not the feedlot's fault that this problem arose. They were doing their business just fine, not bothering anyone. But people sort of encroached upon their facility. They came to the nuisance. And eventually it became impossible for people to live there. It smelled too bad. There was all these flies and risk of disease. So Del Webb sued for what's called a public nuisance, right? Which is something that affects the public at large. Generally, public versus private nuisances. Private nuisances usually affect a small number of people, whereas public affects the general public at large. Usually if there's a public nuisance, there's also a private nuisance, so the terms don't really matter, but this was a public nuisance case. Here, damages would not work, right? People can't live near this infestation. It wouldn't work. So an injunction was the appropriate remedy. But here's the rub. Usually with an injunction, the party causing the nuisance has to pay for the cost to shut down. But here, the Arizona Supreme Court came up with a creative solution. And they made this up. This wasn't a thing. They said that the developer, the Del Webb company, the Spur Industries, right, was required to pay to move the feedlot. In other words, because you came to the nuisance, you are on the hook to cover the costs of moving the facility. And this is a remedy that I think makes a lot of intuitive sense, right? You can't have people living near there, but we should recognize why this problem arose. It arose because of the developer. And you make the developer pay to move the feedlot. Right? And they actually moved it. Del Webb paid an undisclosed amount to compensate for the cost of relocation. So actually, in the end, I think everyone worked out just okay. But this is a case where it wasn't temporary damages, permanent damages, or an injunction. It was an injunction that's paid for by the party being affected by it. I think it's a creative solution. Okay. Question on the Del Webb case. I'm sorry. Oh, Blake, what question 3 are you talking about? I don't see which question in the chat. Oh, I'm sorry. I never gave you the answer. I'm sorry. False. Yeah. Question 3 is false. Damages cannot always fully compensate a plaintiff. Thank you for finding. Oh, Moises, there you go. That's right. All right. Let me wrap up a bit. I'll also start the minute poll so you can start. And please, I read these very carefully. When I see people are not getting something, then I always make a point to revisit it the next class. Again, in this class, I am not concerned with what is a nuisance. If you're answering your exams about, well, this is a nuisance because of an improper use and going into depth, that's just probably wrong. What I'm usually more concerned about is what is the proper remedy? Is it temporary damages? Is it permanent damages? Is it a temporary injunction? Is it a permanent injunction? Or is it like in Del Webb, where you move the feedlot, but it's paid for by the encroaching neighbor? Okay. Any other questions? Going once. Going twice. Have a happy Constitution Day tomorrow, and I'll see you all next week. Thank you so much.